I mean, this is a big item, DTC eligibility. And if you're public, you know what we're talking about. If you're private going public, you're going to know real quick. This panel, everyone here is an expert on the subject. So first I want to introduce Gregg Jaclin, a partner in Anslow and Jaclin law firm out of New York. Gregg. Ian Kass, Wilson Davis, investment banking house. And I want to give a little extra special statement about my friend Seth Farbman. Seth is one of those guys, if you need a favor, he's always there. If you have an issue, he's always there. He's probably one of the most generous guys I've met in, not 40, pushing 40 years in this business. So, Seth, on behalf of everybody, we thank you for everything, especially for all his efforts of NIBA. Seth and Lisa have really gone out of the way to help the organization, and we're real privileged to have him here today. So, Seth.
Thank you for the kind words, Jim. Welcome, everybody. I figure that it's late enough in the day that we can break it up with a little bit of a corny joke. So there was this kid who was going to visit his grandmother. And so before he went to the first time, the grandmother says to him, okay, here are the instructions you have to follow. When you get to my apartment building, take your right elbow and push the button to buzz the door open. And then when you hear the buzz, take your left foot and hook it around the door, and that'll get you into the hallway. And then when you get into the hallway, take your left elbow, third floor, that'll open the inner door, right doorway, right foot, hook it around, you'll be in. And then when you get to the elevator, again, use your right elbow, click the button, you'll be good to go. He says, Grandma, listen, I love you very much, but I'm a healthy kid. Can I ask, what kind of instructions are these? So she says to him, you're not coming empty-handed, are you? Corny, I know, but I think that the point is, nobody from this NIBA conference is going to walk away empty-handed. Everybody's met a lead, a prospect, reconnected with a colleague, so I think we're all walking away with something. So the topic of DTC, I was at a conference probably about 18 months ago, and like many of you in the room, we've all been to conferences, and this was a banking conference, and over the last 10 years, when an issuer gets up there to present in front of prospective investors or funds, the questions used to be, tell me about your management team. Tell me about your projections, your budget, your patents. Now, there's only one question that matters, my friends. Bingo! Are you DTC eligible? And if you're not, they don't even want to get to first base with the other questions. I'm not up here necessarily as an expert, and my colleagues are not up here as experts, because as I look around the room, frankly, I see many people who I know who have been through the trials and tribulations of getting DTC, dealing with DTC, and many of you could probably get up here and give significant insight as well. So we're going to touch on some topics that I think will be beneficial, and by all means, if anybody has any questions, we can talk about that afterwards. I'm going to give a quick introduction, my background, and then we'll talk about the panel. I used to be a securities attorney and started a company called Vintage Filing. So we do the SEC, Edgar, and XBRL and printing for a couple thousand public companies. I sold that company about 6 years ago now, and now focus as well on the stock transfer business, VSTOCK transfer. We're based in New York. I see several clients in the room and friends, and essentially we like to be looked at as the quarterback, because we're in that seat speaking to CEOs and attorneys, whether it's Edgar or transfer agency services, proxy mailings. We own the website DTCEligibility.com, which for some crazy reason is we're the #1 site that comes up when you type in that search term, so we're very thankful for it. So we just have the experience of touching a lot of the different pieces of the puzzle that companies and people such as yourselves could benefit from. And we like to be used as a springboard. If anybody has any questions, we can help with introductions and try to guide when appropriate. So to my left is Gregg. I'll ask you to give a little bit of background.
Thank you, Seth. First, I want to second what Jim said about Seth. Anybody that knows Seth,
stop.
got to take the opportunity. Just the best guy to work it with in the space. Will do anything for you. So if you don't work with Seth, make sure you take the opportunity to at least meet him for everything. Obviously, the transfer agent, but he's just the guy that you need to know if you're operating in the space. My name is Gregg Jaclin. I'm a partner at Anslow and Jaclin. We're a boutique corporate and securities firm. We have 10 attorneys. We're located in New Jersey. We have a small office in New York. And we work with small public companies, microcap, help them get through their filings, file registration statements, 33 Act work, 34 Act work. You know, through our contacts, we try and help assist them in raising money, registration statements, pipes, the whole gamut. And that's basically what we do, is work with our clients and try and help them and work with them as they grow. Ian?
Thanks, Greg. My name is Ian Kass. I have been in the industry for about 20 years now. 19 of those 20 years I've been with almost every small cap firm out there. We use cleared through, you name it, Penson, Legent, you know, any firm you could think of that cleared stock. About 2 years ago, my partners and I figured out that we needed to be self-clearing. So that's
let me just stop you right there. Those are two magic words, self-clearing. Keep that in mind.
Which means we are a DTC participant. So every issuer out there that was told by their broker who submitted a DTC application through Pensons and the Legions of the world and it got rejected, it wasn't my fault. They rejected it. We did everything we can to get it approved. Well, now as a DTC participant, we can actually get these things pushed through along with Seth and with the help of some of the attorneys in here that we work very closely with. But like I said, for the past 19 years, this is what we've done. We know the sector as well or as better than anybody. So at this point,
and we're going to come back to some of the elements that I think Ian's qualifications are going to be important to speak about when it comes to depositing certificates and physical certificates and things like that. So we'll come to that in a second. So I guess the audience I see is comprised of people who have significant experience, maybe some people who are about to embark on this journey of DTC for the first time or going public. So I think that the first question to ask is who is DTC? You know, I probably shouldn't admit this, but I didn't do too much reading as a kid growing up, and I probably don't do too much reading now of the classics. My mother happens to be a literature teacher, of course. But when the movie came out, I watched this movie called Atlas Shrugged. I'm told it's a classic. And part of Atlas Shrugged, there's one line that goes through the entire movie, right? What's that line? Who is John Galt? John Galt is supposed to be this guy that is like the ideal person, and the whole movie is, who's John Galt? Who's John Galt? Nobody could figure out who he is. Does he exist? I kind of feel that way about DTC. Who are they? Who's running quadrillions worth of dollars through their system? Who are we answering to? Who are we trying to get approval from? So to answer the question of who is John Galt, I will ask Greg to tell us about DTC.
I'm going to try and talk without the microphone. You guys need the microphone? Everybody hear us? You need it? I'm going to try and keep it real simple in terms of what DTC is. DTC is the company that basically controls the process. It's a clearing firm that allows you to electronically trade your shares. Without DTC, or if you're not DTC eligible, you're required to clear or trade certificates through the hard certificates, which, as you can imagine, is pretty much impossible. It doesn't really allow you to trade. So DTC has set themselves up where they basically control the process of allowing you to electronically trade your stock.
So the question is, and many companies come to us and they ask us, well, why do I need DTC eligibility? It doesn't necessarily directly affect the trading of my stock if I'm on, let's say, quoted on the OTCBB. So the important analogy, and this is, I guess, primarily towards some of the issuers out there or the CEOs, the best way to explain it is like this. If I want to invest $1 million in your company, so what happens? Without DTC eligibility, I'll write you a check. Then what happens? You'll instruct your transfer agent to cut a stock certificate. The transfer agent will FedEx it to the shareholder. The shareholder now FedEx it to their brokerage account. The broker now FedEx it to the clearing firm. The clearing firm FedEx it to CD. Am I right so far, Ian? I got my process straight? And it's weeks before I get, you can have the best transfer agent out there, the best clearing firm out there. It's just process and paperwork. And it could take weeks till I get my certificate back. And if I'm putting $1 million into a deal, it'd be nice to have the shares electronically deposited into my brokerage account within 2 hours. And that's essentially the ultimate goal of being DTC eligible. The other frustration, if you're living without DTC eligibility, is just the basic expenses. There are some firms out there that to deposit a certificate is $1,000, $1,300. I literally had a certificate worth $400 that I had to pay. I had to have $25,000 in the account and pay $1,300 as a deposit fee to deposit my $400 certificate because the stock was trading under 10 cents. So by achieving DTC eligibility, you eliminate the need for physical certificates and reduce costs both for the issuer and for the shareholders. It also works on the flip side in terms of wanting to get certificates out of CD and DTC. I was doing a deal, and I was actually a shareholder, and again, it was small. It was like $500 worth of stock, and I could not get my certificate back. It took close to 3 months to get my certificate out of CD, and granted, they were having trouble because of the Sandy storm back on the East Coast. You know, 55 Water Street is where DTC is, and the irony is that the DTC vault was flooded. You would think that that there were precautions in place, but there weren't, and as a result, there are many, many deals and shareholders that had to deal with that frustration of getting certificates out. So there are many reasons why DTC is of value. Gregg, from a deal standpoint, maybe you can elaborate if you've seen, are companies more valuable if they have eligibility? Another question that I've been asked recently is, if they do a merger or acquisition, does that affect their current status as DTC eligibility? Maybe more from the deal flow standpoint, you could elaborate.
Well, let's talk first about, you know, deals in terms of raising money. You know, from my experience, investment bankers, funds require it. I mean, they're not going to come in and allow you to give you money basically if they're going to have to trade physical certificates. So they're going to require that the company be DTC eligible, be DWAC eligible, so that they can get the shares electronically, trade them electronically. They don't want to wait. They want to be able to do everything immediate. So from, you know, based on my experience, there is, you know, funds won't fund you, you know, without being DTC eligible.
I agree 100% with Gregg. And the other factor when you come to DTC eligibility, it's not just that it makes it more difficult to trade, it makes it more difficult to transfer between buyers and sellers, but the cost of not being DTC eligible is an extraordinary expense for the issuers and the clients. Because one thing that has to happen, and if you understand what X-clearing is, it means that the actual physical delivery of a certificate has to happen. So if you have a shares deposited in their physical delivery, you sell them to whomever you sell them to, they got to get sent back to the transfer agent, cut from the shareholder's name to the new shareholder's name. And obviously everybody knows the expense of the overnights, the transfer from name to name, and then the transfer into the new name. The other problem is the liability with that. The delivering firm, because of the rules and regs that we all have to deal with, there is a good possibility that those shares can actually be denied because they don't want the physical delivery of it. So there is also another liability on the broker-dealers that are accepting non-DTC eligible trades because of the risk in not getting delivery in time, buy-ins, and everything else that goes along with not getting your shares delivered electronically.
Great. Hey, go ahead.
No, if you want me to talk about a little about the reverse mergers, my experience has been, at least recently, that you do not lose DTC eligibility if you do a reverse merger. Depending on the deal, they might look at it. There's a possibility they could put a chill on it, but my experience is, at least recently, that, you know, the companies that have done reverse mergers with DTC companies, DTC eligible shells, have not lost their eligibility. You know, I don't know if you've seen it at all. Well,
there was a time, and this was going back almost 6 months now, where that has changed. Prior to that, there was a time period for about a year that any issue that did a corporate action, whether they did a reverse split, a name change, symbol change, issued a certain percentage of shares over their current outstanding, would get a chill. Because the SEC basically put their foot on the neck of DTC and said, you're the gatekeeper, you're the ones that are responsible for the shares being traded. So basically what happened is DTC took the stance, well, any shares that are issued or reverse split or anything like that where there's an enormous amount of shares being issued at any one particular time, well, we're going to put a chill and wait for a participant along with their attorney to write a letter saying, no, everything is good. They didn't want the liability. But from what I understand, one of the attorneys are in this room, and I forget which one it was, actually took DTC to court. And since then, DTC, if they put a chill on, I think the rule is 48 hours. They have to have a hearing and give you a reason why. So the splits and the reverse mergers are no longer really being affected by DTC when it comes to a chill.
And I think Ian brings up a good point. There's a very clear distinction in definition between DTC eligibility and a DTC chill. I want to spend a few minutes on the chill aspect because that affects some of the current issuers, but I also want to just lay a couple of the misconceptions that I've heard recently on the initial eligibility part of the process. You know, that game Truth or Dare, or Truth, False or Dare. There are a couple of things out there that are just not true when it comes to DTC applications. Companies come to us and they say, well, I can't get DTC eligible because I don't have at least $100,000 in revenue. That's false. In other words, that misconception of having to have $100,000 in revenue, I don't believe ever has or ever was a DTC mandate. It was a threshold that some of the clearing firms like Penson wanted to put in place internally, and sort of that just got out as the myth of, oh, well, you have to have $100,000 in revenue. That's not the case. Same thing, oh, I heard my stock has to be traded at least 10 cents. Again, not the case. That's up to the discretion of the individual clearing firm or DTC applicant that's going to be sponsoring the application. The process has gotten significantly better over the last 6 months. I would say a year ago, there were significant stumbling blocks. I mean, sometimes it took 3 to 4 months to get something eligible, whether it was because of the paperwork or the review process. Now, some of the eligibilities are being granted within 10 days to 21 days, something in that range. And then the DARE part of it is whether or not you can get a shell DTC eligible. That's a dare that you would have to take. I think that also is probably a discretion of the clearing firm, whether or not they want to take it. I know most probably will shy away from it, but not a DTC requirement. Okay. But so let's jump right into the important distinction of this world of DTC eligibility, of the first-time applications versus the actual chill. It's funny, my kids, when they were, well, some of them still are younger, but my daughter in particular, she says, you know, when I do this, it hurts. I'm like, well, then don't do this, right? The companies out there, like, what do I have to not do to make sure that after I've worked so hard to gain DTC eligibility, that I want to maintain that and keep it without a chill being put in place? And I have to say that the frustrating part of the process with a chill that I hear from most CEOs is that there's no letter that goes to them. There's no mandate. There's nothing that comes to their attention that says you've been chilled. It happens to be if somebody tries to sell the stock, a shareholder, and their broker lets them know that they see a chill, then suddenly the CEO will get a call and somebody will tell him, hey, your stock is chilled. What's up with that? And only then can they start the process. So that's part of the frustration of the chill world. But I'm going to turn to Gregg, because this is much more of a legal undertaking in terms of correcting the chill issues.
So I think Ian touched on a lot of the reasons why a chill, goes into effect or has gone into effect in the past. Forward split, reverse splits, a lot of free trading shares hitting the marketplace at once. If there's somebody under investigation at the company, obviously a reverse merger. Those in the past were reasons why DTC would put a chill, which basically means you're still DTC eligible, but you can't trade electronically, so you might as well not be DTC eligible. And again, in the past, it's been very frustrating for issuers because they have not been able to get answers. They might not even know they're DTC eligible until months after, as Seth just said. But the biggest problem was they couldn't get answers. There was nobody to deal with at DTC. Then a couple, I guess it was about a year and a half ago, no, it was a year ago. Now the case came out and the SEC pretty much put it to DTC and said to DTC, you need to start explaining this. And I think since then it's gotten, I don't want to say easier, but at least there's an avenue. There's a way to go. You can now go through and talk to DTC and find out what the chill's about. They will provide you with a letter explaining what the problems are, the issues are. They will address it. You can then appeal it. You can then go through the process of explaining where the free trading shares came from. So I think now a chill is not as much of a death knell as it used to be, where a chill basically meant you were never going to get DTC eligible, and companies fought the battle for years upon years. Meanwhile, shareholders couldn't basically trade their shares. So the process has definitely gotten, again, I don't want to call it easier, but it's definitely, now there's a way to go. Before there was nobody to talk to. You try and contact somebody at DTC, get no answers whatsoever. At least now it takes time. You got to walk through the process with them, but at least you can get through it.
That's correct. Like you said, before there was no answers. And I was at the SEC roundtable a year ago in D.C., and this is one of the things that was discussed. DTC did not want to give out criteria. They didn't want to give out guidelines because they figured anybody going to do anything wrong will go just up to that edge, which, as we know, a lot of people do. So basically, they didn't want to give out that guideline. So what we did and we tried to get to understand is what we needed to do to get a company that shield removed. And basically, it took a letter from the attorney presented by the DTC participant to explain the split or the reverse or whatever it was that gave the company that chill status. So now that we have the roadmap to get those chills lifted, we can certainly get those done now.
And again, I feel somewhat humbled because I know many of you in this room have actually dealt with this for weeks, months, if not years. You know, some of the items can be corrected. It's just a matter of extreme diligence and hard work, whether it's dealing with providing the underlying documentation, legal opinions. Sometimes the shareholders might be in question. It has nothing to do with the issuer itself. Just as a side plug, we have a company called VSTOCK Global, which does background checks and due diligence both for shareholders and individuals. So that's something that has become significantly important in terms of the backgrounds of people that you're doing business with, whether it's executives or bankers. And obviously, if there's a regulatory action against the company, that might come into play. And these are all things that, if confronted with head-on with counsel, I think that with extreme persistence, you'll be able to overcome and get through it. And then there are those cases, and this goes even for the attorneys, where they can't get that memo from DTC that outlines what the concerns are, right? I mean, it's one thing to be able to get that memo that says our concerns are A, B, and C, and then be able to address them. But sometimes you can't even get that memo that outlines what they are, and you can call DTC, and sometimes it's a question of them saying, well, you're not, you know, they'll tell the issuers perhaps that you're not counsel, they'll tell counsel you're not the transfer agent, they'll tell the transfer agent you're not a participant, and it could go round and round in circles. Feel free to contact me afterwards. There are certain email addresses of certain people at DTC that we do know that handle these issues. Again, work the room. A lot of capable people here that have dealt with these issues and could also shed some guidelines. I want to just wrap up on a couple of the eligibility aspects, and then we can see if there are any questions. I want to remind, I guess particularly the issuers, that DTC is just the first step of the journey. In other words, a lot of times people come and they get DTC eligible, and then they say, okay, why can't I put shares into my shareholders account now? Well, you've only done Part A. Part B is now you have to get approved for the FAST system, and that's to be able to DWAC. I love DWAC, FAST, EDGAR, all the acronyms out there, CNS, DTC. And that's an important component as well, because just fact, you could go ahead and be successful at getting DTC eligibility, then you make an application again with DTC for fast approval to be able to have your shares electronically deposited and be rejected. I kid you not, the language of the email that comes back is thank you for your fast application, something to the effect of at this point in time your application has been denied, please try again in 2 or 3 months. Have a nice day. No specific reason given, and frankly, under the rules or guidelines, they don't have to give a reason. Sometimes it could be because there aren't enough shares deposited at CD, which is something that can be addressed, and then the company could apply again. But I just wanted to point out that that's a two-step process. And as I said, it's a few weeks to get the DTC eligibility component, and then likely another 2 to 3 weeks on the FAST component.
Just to clarify, there are situations where your transfer agent is not DWAC eligible, is that correct?
That's a separate question, and it's a good point. There are transfer agents. The transfer agent also has to be DTC approved and DWAC eligible. VSTOCK transfer is, and there are some transfer agents out there that are smaller and that are not licensed, if that's the right word, and so therefore automatically you won't get out of the gate if they try to make the application. So make sure that your transfer agent has that experience. Now you've got DTC eligibility. The unwritten rule is that you should make a deposit with a broker in street name to deposit into CD within 30 days of getting that eligibility. Herein, again, is where a firm that's a self-clearing firm is going to become very valuable, because sometimes what you'll have is a company that just received DTC eligibility approval, but they don't yet have a bid and an ask. So they may go to several brokerage firms that won't accept a physical certificate for deposit because there's no bid and ask. And now this company is in a difficult position because they got the eligibility, but they can't make the deposit in order to lock it up. Anything to add on that?
Real quick. Seth said it is mandatory to have a share deposited with CD&Co within 30 days. If on that 31st day, if there are no shares in the system, that you will lose eligibility and have to start all over again.
Okay, that's a confirmation. Mandatory.
Mandatory.
Within 30 days.
30 days to get shares on deposit.
So that's a very broad overview of both the eligibility and the chill side. Started with a joke, I'll end with a joke. I didn't bomb too bad the first time. There's a couple, and they're living in a neighborhood, and I know you've heard this already. And there have been a lot of robberies in this neighborhood, and it's an elderly couple. And one night they're sitting up there in their bedroom, and they hear rustling going on, and they get concerned. All of a sudden, a burglar bursts into their room. They're terrified. It's an older couple. They don't know what to do. They're shaking. All of a sudden, the guy pulls out a gun, and he points it at the wife's head, and he says, "Tell me your name. Tell me your name." And she panics. She thinks for a second, and she says, "My name's Elizabeth." And he says, "You're lucky. My mother's name was Elizabeth." And he puts the gun away. Everybody breathes a sigh of relief. All of a sudden, the guy pulls out the gun again. He points it at the husband. He says, "Tell me your name. Tell me your name." And he thinks for a second. He says, "My name is Jack, but my friends call me Elizabeth." Again, corny, I know. But the message being that a name and a reputation is everything. And so I think that who you use for every service provider in the public industry, whether it's a transfer agent, investment banker, Edgar agent, attorney, auditor, across the board, reputation is everything. So with that, I thank you. Elizabeth thanks you. And if anybody has any questions, we'll open up the floor. Any questions? Sure. Yeah, go ahead.
Okay. Well, okay, the gentleman asked what the DTC process is. Well, like Seth said earlier, the clearing firms had their own ideas of what they wanted to submit the application, and I'm going to tell you what the real requirements are. At a minimum, there needs to be a prospectus filed, whether it's an S1 or a Form 10, just some sort of prospectus. We need to have a shareholder list. We need to have a copy of a certificate. We need to have an attestation from the transfer agent verifying shares outstanding. And we need the opinion letter from counsel. That's it. That's all we need to file a DTC application, and of course the fees involved.
I'll tell you honestly, I think it's also a question of the presentation of the package to DTC. In other words,
of course.
I think these are the requirements that everybody needs, but it's also, I think, helpful to do. And we all try to do this as best we can in terms of diligence, because so often a sloppy application, although the application itself, oddly enough, is just one page, but although a sloppy application can cause weeks, if not months, of confusion. I mean, if the QSIP number is wrong, if the number of shares outstanding is off by one share, we had one issue. I mean, I think we've submitted probably close to 60 applications over the last 18 months. Fortunately, thank God, we've been 60 for 60 or something to that effect. But one time a question came back, and that the attorney was actually disbarred. The attorney that was on the application was disbarred. Now, to his credit, it was, lack of CLE, keeping up with all that, whatever. But there's an element of everything has to be precise in order for it to really go through.
And I did miss one item. We do need the FINRA 211 approval. And that is basically it.
But that's the overall process.
Yes, I mentioned that.
Any other questions? Yes. So to clarify, not that it would cause a chill, but it could perhaps cause a rejection of fast eligibility. I don't know if there is a particular number. I mean, I've seen 5 to 10,000 shares rejected, and I've seen 100 to 200,000 shares deposited. That's fine. Have you seen any?
From what we understand from DTC and FINRA with a lot of these questions, it's the need for certain things to be done. What I mean by that is, if there's only 10,000 shares, 100,000 shares of out of 100 million shares in the float, what's the need for that service? Like when there's 8 shareholders on an S1 registration and we do it to 11, they're like, what's the need for this company to go public? So basically, when there's enough shares in the system for the need for it to be done electronically, that's when they allow it. When the shares are trading enough volume, when there's enough shares in the system and there's enough public need for electronic transfer of these shares, that's when they say okay. Well, I've never heard of that say there's a number of shareholders needed, but if you take it back a step, there is kind of a guideline we have that you need a certain number of shareholders to do it to 11, which is the first step. We use a guideline is 25 shareholders at a minimum. We prefer 35, but the more shareholders you have, the more there is what they call the public need. If you have 3 investors, 3 shareholders, then what's the public need for this company to be public? So the more shareholders you can have when you start this process, the better off you are and the better chance of having a smooth transition through each of these steps. Because they're worried about concentration. If there are a handful of shareholders, then they can control and dominate the market, and obviously we know they're all worried about the pump and dumps. The activities that caused all these problems are those type of activities, and that's what they're trying to prevent against. So if you've got 100 shareholders, you've got a much better chance of going through the system without a problem than 10 to 15 shareholders.
Any other questions?
I'm not saying that. That's the guidelines we work towards because, like I said, if you have 4 shareholders, well, what's the public need?
To clarify what Ian is saying is, with 4 shareholders, you're not going to be able to get through FINRA to get your symbol anyway. So, you know, I mean, once you're there, presumably you're going to have a marketplace that won't have 4 shareholders in it, but you wouldn't be able to get through FINRA to even get to DTC if you have only 4 shareholders.
Yes? Okay. Well, thank you everybody for your attention. Enjoy the rest of the afternoon. Have a great day.